Well, good morning. I am joined this morning by Kate Hogan, who is the president of the New York State District Attorneys Association and also is the district attorney of Warren County and represents all 62 district attorneys in the association. And we're joined also by our home district attorney, Cy Vance, and Queens District Attorney Richard Brown, Bronx District Attorney Robert Johnson, and also we're joined by Dan Donovan, who's the District Attorney of Staten Island, and also by Ann Swern, the first District Attorney of Kings County, representing the District Attorney of Kings County, Joe Hines. Also, we're joined by Nassau District Attorney Kathleen Rice, who's here this morning, and all of these individuals are guardians of justice. They are all protectors of the most vulnerable people in society. They are our first line of defense in the criminal justice system against a lot of domestic crimes in this state. And also, as they are known as crime fighters, they also shield us from one of the most formidable situations that occurs, fortunately, once in a while, but still too often, where innocent people are accused of crimes. And we today have a great deal more opportunities to prevent these types of situations. We have technology and we have data that can help to prevent crimes that are about to be committed, solve crimes that were committed some time ago, and exonerate people who are falsely accused. Unfortunately, these district attorneys and other law enforcement officials are tied up in a lot of government red tape that I hope we're going to start eliminating today. And of course, the problem-solving mechanism is DNA evidence. And DNA evidence is not used in 46% of penal violations as it stands right now. Unbelievably, DNA evidence cannot identify all of the people on the sex offender list. There are people who are convicted of degrees of arson and even selling, providing contraband to prisoners who are not on the DNA list. And all it does is allow individuals who are not on the DNA database to continue committing crimes and have their DNA protected from the kind of check that would reveal who the true perpetrators of these crimes may be. And one of the cases that we read when we were researching to move this legislation and to change our regulations would effectively be the case of Raymond McGill in Albany. Mr. McGill was convicted of two basically minor offenses. However, later on, he was linked to the rape of an 85-year-old woman, the murder of a 50-year-old woman, and the murder of a 68-year-old man. Had his DNA been collected, we can't guarantee you that he would have been arrested for any of these other crimes, but certainly after the rape, had we been able to check his DNA, we might have been able to prevent the two murders. So what do we say to the families of crime victims in situations like this? We say to them that we're going to do everything possible to apprehend those who committed these crimes. We are going to try any means necessary to bring criminals to justice. But we haven't been doing it. Today, what we are going to do is to expand the DNA database to include anyone convicted of a penal felony, anyone convicted of a penal misdemeanor, the adjudication or youthful offender status provided to youths who violate the penal code, and also anyone on the sex offenders list, whether they were convicted prior to the establishment of DNA or whether they were convicted out of state. They will all be in the registry. We will now be able to allow all of the individuals who have committed crimes in the past to be on the list of those whose DNA we will check for potential crimes in the future. This will solve crimes that were committed a long time ago, prevent crimes that have been committed recently, and exonerate those who were falsely accused or falsely convicted of crimes based on the fact that we didn't have the available evidence. And so this is a giant step forward. We believe in crime fighting, and also making sure that the right people are brought to justice. And basically, we got a lot of the information from so many of the district attorneys who you see here today, because it's really kind of a modern crime-fighting understanding that smaller crimes are the prelude and the catalyst for the commission of larger crimes. So no matter how far you go back, whether you read Blackstone or Fleta or the McNaughton rules or whatever it is, the reality is that this is something that's really been examined and known for thousands of years. And we are expanding a new crime-fighting tool, the DNA Databank, to incorporate the needs of 21st century crime-fighting techniques. So thank you all for being here. And now, if any of you would like to say anything.
Good morning, Governor. Thank you so much for convening us. As I said, I'm Richard Aborn. I'm president of the Crime Commission. There are a number of speakers, so I will be brief, but I will also be perfectly blunt. If I were to stand here before you and announce that law enforcement was going to stop taking fingerprints from 54% of all the people convicted of crimes, you would be aghast. You would say, why would you do that? Functionally, that is what we are doing by not taking DNA samples from everybody who was convicted of a crime under the penal law. Some 54% of the people who are convicted right now do not have DNA samples taken. That is an unnecessary waste of evidentiary leads. We can solve many crimes, but more importantly, we can prevent crimes by taking DNA samples. The Citizens Crime Commission has long stood behind the idea that we should take DNA for all penal law convictions. We should treat it just the same way we treat fingerprints. It is time to do that now. This is a win for the prosecution bar. This is a win for the defense bar. But frankly, far more importantly, this is a win for the people of the state of New York. Thank you.